The lens was pointed directly at my daughter's window. Not the street. Not the common area fence. Her second-floor bedroom, where the blinds had been open for 10 years because we backed onto empty conservation land and nobody had ever had a reason to close them. I was holding the county easement map when I saw it, the original 1987 document my attorney had just couriered over, and I remember thinking very clearly, they have no idea what they just gave me. Let me take you back 3 weeks. The letter arrived on a Tuesday. Cardstock envelope, Pinehurst Meadows HOA return address, the kind of presentation that wants you to believe it carries more authority than it actually does. Inside was a single page informing me that surveillance equipment would be installed along the rear property line to monitor community safety and covenant compliance. No date given, no equipment specifications, no request for input, just a notification that cameras were coming. I read it twice, set it on the kitchen counter, and called my lawyer. Diane Merrick had been the HOA board president for 6 years. She ran the neighborhood like a corporate department. Quarterly reviews, violation tracking, an enforcement subcommittee that met monthly to discuss whose mailbox was the wrong shade of black. She was methodical, confident, and genuinely believed that structure was the same thing as authority. She was wrong about that. The cameras went up on a Thursday morning while I was at work. I got the text from my wife, Angela, at 10:47. There's a crew in the Greenbelt. They're mounting something on poles. I told her to photograph everything. Positions, angles, pole heights, the crew's truck, the equipment boxes. She sent me 14 images by noon. The installation was clean and professional. For cameras on 8-foot galvanized posts, spaced evenly along the tree line that bordered the rear of our lot and 3 others. Each camera was angled slightly downward. From the positioning, I could see they were covering more than the Greenbelt. They were covering our yards, our patios, our rear windows. One of them had a direct line of sight into my daughter's bedroom on the 2nd floor. Chloe was 16. She was careful, private, the kind of teenager who closed the bathroom door even when nobody was home. The idea that a camera had been placed where it could observe her window, installed without notice on land the HOA did not own, made something very cold settle in my chest. I did not call Diane. Not yet. I finished my workday, drove home, and stood in the backyard with Angela while the late afternoon sun hit the camera lenses and made them glow faintly like animal eyes in brush. Can they do this? Angela asked. I told her I didn't know, but I was going to find out. That evening, I walked the property line with a tape measure and a notepad. The cameras were mounted on the far side of the split-rail fence that marked the edge of our subdivision. Beyond the fence was a 50-foot wide strip of unmowed grassland, then dense oak forest. The strip had always been there. We had been told at closing that it was conservation easement, protected greenbelt, land that couldn't be developed or disturbed. I had believed that because I had no reason not to. But standing there in the last of the daylight, looking at 4 steel poles sunk in a soil that nobody had touched in 30 years, I started to wonder what the actual legal description of that easement said. Not the general idea, the recorded instrument. I called Tom Feldman the next morning. He had handled our closing in 2014 and kept copies of everything. I asked him to pull the full easement chain for the conservation land behind our street, every recorded document going back to the original subdivision plat. He said it would take 2 days. I told him that was fine. While I waited, I did my own research. I pulled the HOA's governing documents from the county recorder's website. I read the covenants, the articles of incorporation, the amendments from 1987, 1994, and 2008. I looked for any language granting the association authority over the conservation easement. I found nothing. The easement was referenced once in a 1987 site plan attached as Exhibit C, but only to note its existence as a boundary feature. There was no grant of access, no maintenance clause, no language suggesting the HOA held any interest in it at all. On Saturday afternoon, Diane Merrick sent a community-wide email. The subject line read, New Safety Initiative. The body described the cameras as a proactive measure to deter vandalism and ensure compliance with community standards. It included a reminder that all residents were subject to exterior property covenants, and that the board retained authority to enforce those covenants through necessary means. It did not mention where the cameras were installed. It did not mention that they were pointing into private homes. 40 minutes later, my neighbor Carl Hoskins called. His patio backed onto the same greenbelt. One of the cameras was angled across his hot tub. "Did you get the email?" he asked. I told him I had. "John, my wife hasn't gone outside since Thursday." I told him I was working on it. Tom's courier arrived Monday morning at 8. Inside the envelope was a file an inch thick. The original 1987 plat, the conservation easement deed, a title opinion from the developer's attorney, and 2 amendments I had never seen before. I spread them across my kitchen table and started reading. By page 4, I knew Diane Merrick had made a mistake she didn't understand yet. By page 9, I knew exactly how to prove it. The easement deed was dated March 12, 1987. It granted a perpetual conservation restriction over a 50-foot strip of land running the entire rear boundary of Pinehurst Meadows subdivision. The restriction prohibited development, clearing, grading, or installation of structures. The land was to remain in its natural state in perpetuity. The holder of the easement was the Pinehurst Meadows Homeowners Association. I read that line 3 times. The HOA didn't own the land. They held an easement over it, which meant their authority was limited to the specific rights granted in the document. I kept reading. Section 4 was titled Permitted Uses. It listed exactly 2 foot traffic on existing informal trails and maintenance necessary to prevent fire hazard or invasive species spread. That was it. Nothing about infrastructure. Nothing about surveillance equipment. Nothing that could reasonably be interpreted to allow the installation of 4 steel poles and hardwired camera systems. Section 7 was titled Prohibited Activities. The list included construction of any permanent or semi-permanent structure. I set the deed down and picked up my phone. I photographed every page, exported the images to a labeled folder, and forwarded the full set to Tom Feldman with a subject line. "Does this say what I think it says?" Tom called me 40 minutes later. "Yes," he said. "They violated their own easement." I asked him what that meant practically. He said it meant the HOA had installed equipment on land where they had no legal right to install it, and that their authority as easement holder actually prohibited exactly what they'd done. Any enforcement action they took based on footage from those cameras would be fruit of an illegal trespass. I asked him what the next step was. Document everything, then file. I spent Tuesday setting up my own camera. I mounted a wireless unit on the corner of my roof with a clear view of the greenbelt and all 4 HOA cameras. The unit logged to local storage and cloud backup. I set the timestamp to UTC and enabled motion tagging. Then I did something that felt slightly theatrical but turned out to be tactically necessary. I opened Chloe's blinds and placed a small visible sign in the window that read Surveillance Notice. This window is monitored. I wasn't installing a camera in her room. The sign was a marker, a clear, documented indicator that the occupant of the space had a reasonable expectation of privacy and was actively aware of being observed. If the HOA reviewed their own footage and saw that sign, they would know we knew, and they would have to make a choice. That same afternoon, Diane sent a violation notice to Carl Hoskins. His hot tub cover was cited as non-compliant with community aesthetic standards due to fading. The notice included a reference to recent observational review and required correction within 14 days. Carl forwarded me the email within minutes. I saved it in the same folder as the easement deed. Wednesday morning, I sent a formal written demand to the HOA board via certified mail and email. The letter identified the 4 cameras by position, described their sight lines into private homes, attached the relevant sections of the easement deed, and noted that the installation violated both the easement's express terms and state statutes regarding video surveillance directed at residential windows. I requested immediate removal of the equipment and destruction of any footage capturing the interior or private curtilage of affected homes. I gave them 7 days to respond. Diane called me Thursday evening. I let it go to voicemail. She left a 2-minute message explaining that the board had acted within its authority under the covenants, that the cameras were positioned in common area space, and that my interpretation of the easement was overly technical. She said she hoped we could resolve this cooperatively. I did not call her back. Instead, I filed with the county Friday morning. 2 separate actions, a cease and desist petition under the state surveillance statute, and a declaratory judgment action asking the court to confirm that the easement language prohibited the installation. Tom attached the easement deed, the site photos Angela had taken, and stills from my roof camera clearly showing the sight lines into Chloe's window in Carl's patio. We filed at 9 o'clock. By 10:30, the HOA's registered agent had been served. Diane sent the community-wide email that afternoon. The subject was Legal Action Update. She wrote that a resident had filed a meritless claim regarding community safety equipment, and that the board was confident in its legal position. She reminded residents that frivolous litigation harmed the community and increased dues. She did not name me. She didn't have to. Carl texted. She's trying to turn the neighborhood against you. I told him that was fine. Let her. That weekend, I printed the easement deed in full and hand-delivered a copy to every house on our street. I included a cover note, one paragraph, explaining that the conservation land behind our homes was subject to a restriction prohibiting permanent structures, and that the cameras had been installed in violation of that restriction. I did not editorialize. I did not ask anyone to take my side. I simply provided the document. By Sunday evening, I had received texts from 4 neighbors asking questions. By Monday, 2 of them had contacted Tom's office asking if they could join the action. Diane's response came Tuesday morning. Another violation notice, this time to me. My front hedge exceeded the height limit by 4 inches. Correction required within 10 days. I measured the hedge with a tape measure, photographed it against the covenant specification, and confirmed it was compliant. I added the notice to the file and smiled. She was giving me exactly what I needed. The hearing was set for 3 weeks out, but the HOA blinked long before we reached a courtroom. Tom filed a motion for preliminary injunction the Monday after I distributed the easement deed. He argued that continued operation of the cameras caused irreparable harm to the privacy rights of affected residents, that the HOA's installation violated the express terms of their own easement, and that their attempt to use the footage for enforcement actions compounded the violation. He attached my roof camera footage showing the direct sight line into Chloe's window, Carl's declaration describing his wife's refusal to use their patio, and the 2 violation notices Diane had issued immediately after I raised the legal challenge. Clear evidence of retaliatory enforcement. The judge scheduled an expedited hearing for the following Thursday. That Wednesday night, Diane Merrick resigned. The announcement came via email at 7:42 p.m. She cited personal reasons and a desire to spend more time with family. The vice president, a retired engineer named Richard Voss who had been on the board for 8 months, assumed interim leadership. Richard called me the next morning before the hearing. "John, I reviewed the easement deed. I also talked to our attorney. We don't have a leg to stand on, do we?" I told him that was correct. He asked what it would take to resolve this. I said, "Remove the cameras, destroy all footage, issue a written acknowledgement that the installation was unauthorized, and agree to a recorded amendment clarifying that the easement prohibits surveillance infrastructure." He said he'd bring it to the board. By Friday afternoon, I had a signed settlement agreement. The cameras came down the following Tuesday. The same crew that installed them returned with a truck and a ladder. I watched from my kitchen window as they unbolted each unit, coiled the cables, and pulled the posts. Angela stood beside me with her arms folded, not saying anything, just watching. When the last pole came out of the ground, she exhaled. Chloe came downstairs and stood in the doorway. "Are they gone?" I told her they were. She nodded, turned, and went back upstairs. She closed her blinds anyway. I didn't blame her. The footage destruction was handled by a third-party digital forensics firm retained by the HOA's attorney. They provided a signed affidavit confirming that all video files from the 4 cameras had been irrecoverably deleted and that no copies existed on any HOA server or backup system. The recorded easement amendment was filed with the county 3 weeks later. It added a single sentence to Section 7 of the original deed. Installation of surveillance, monitoring, or recording equipment of any kind is expressly prohibited. Richard Voss sent a community-wide apology on behalf of the board. It was brief, factual, and did not attempt to minimize what had happened. He acknowledged that the installation had been conducted without proper legal review, that it had violated residents' privacy, and that the board had implemented new policies requiring attorney consultation before any future infrastructure decisions. It was the first HOA communication in 6 years that felt like it came from actual human beings instead of a compliance department. Carl's hot tub violation notice was rescinded. Mine was as well. No penalties. No record. 2 months later, the board held elections. Richard ran for president. He won with 72% of the vote. Diane Merrick moved out of the neighborhood in November. I heard from another neighbor that she'd taken a position in Oregon. I didn't follow up. There was nothing left to say. Chloe eventually opened her blinds again, but it took until spring. One morning I came downstairs and saw sunlight pouring into her room from the rear window. The same light that used to wake her up when she was small. Angela noticed it too. "She's okay," Angela said. I nodded. She was. The conservation land behind our house is still there, unchanged, the way it was always supposed to be. Brass and oak trees, and the occasional deer moving through at dawn. No poles, no cameras, no lenses pointing where they don't belong. I kept the easement deed in a file folder in my office, not because I expected to need it again, but because it reminded me of something I had learned and wanted to keep clear. Authority that isn't supported by the actual words on the actual page is just performance. And performance ends the moment someone asks to see the script. The HOA still exists. It still enforces covenants. But Richard runs it differently. Emails before notices, conversations before citations, and no decisions about other people's property without checking whether the power to make them actually exists. I see him at the mailbox sometimes. We talk about lawn care and county road work and the osprey nest someone spotted near the pond. We don't talk about cameras. We don't need to.